Hello friends, in the series on income tax cases, today we will discuss a very important case which is based on jurisdiction of assessing officer, especially in case of non-resident assessee. The issue before Jaipur ITAT was that in case of an assessee whose profile is non-resident in the PAN profile, but the notice under section 148 has been issued by an assessing officer who is not of an international charge. So whether in that case the assessment completed on the basis of the notice issued by a non-jurisdictional assessing officer is a valid assessment. This issue has been taken up by the Tribunal Jaipur B bench in the case of Sunil Chablani versus Commissioner of Income Tax International Taxation, and this case is reported in 116 ITR Tribunal at page number 187. The date of the judgment is 22nd July 2024. The present case relates to the assessment year 18-19. In the present case, the assessee is an individual non-resident assessee. The assessee has not filed his income tax return for the year, and during the previous year relevant to the assessment year 18-19, the assessee has sold an immovable property. Since the assessing officer do have this information that the assessee has sold some property and has not filed the return of income, the assessing officer, without knowing or without determining the status of the assessee from the PAN details, whether he is resident or non-resident, issued the notice to the assessee under section 148, and this notice has been issued by the assessing officer of Ajmer, who was not of international charge. When the proceedings were going on, the assessee did not submitted any response, so the assessing officer made a draft assessment order under section 144C and sent it to the dispute resolution panel, suggesting the addition under section 69A for unexplained money. The DRP, while giving its direction, said that in the present case the addition should not be made under section 69A, but the addition should be made under the long-term capital gain. And accordingly, the assessment was made. When the matter was before the tribunal, the assessee raised the ground of jurisdiction first time by an additional ground which was admitted by the tribunal by saying that legal ground do not need any new facts to be brought onto the file. So the legal ground can be admitted at any stage. The tribunal said that in the present case, the assessing officer did not take any heed to determine the residential status of the assessee from the PAN details, and it was also noticed that even the National Faceless Assessment Center during the assessment proceedings have apprised that they are not competent to pass the order, because in case of a non-resident, the assessment order is not to be passed by the National Faceless Assessment Center but by the international charge. When the tribunal heard the whole matter, the tribunal said that in the present case there is no denying the fact that the assessee is non-resident, and there is also no dispute that the notice has been issued by the assessing officer Ajmer, who was not of an international charge. So all the assessment based on the notice issued by an assessing officer who was not of an international charge in case of non-resident, so the whole assessment proceedings are bad in law. Friends, this case is very important because in case of non-residents, it has been seen that this type of mistake is being done by the department in a number of cases. So at whatever level the proceedings are, it is very essential to know that what was the basis of issue of notice, who has issued the notice, because this mistake has been done in a number of cases, that in case of non-residents, the notices has been issued by those officers who were not of the international charge, especially in those cases where the status of the assessee was appearing in their PAN details as non-resident. Because in the present case, the assessee was not filing the return of income, so the residential status cannot be determined from their returns, but the status of the assessee was very clear from the PAN details. So in this case, the whole assessment proceedings were demolished solely on the ground of issue of notice under section 148 by a non-jurisdictional assessing officer. At the end of this video, once again I am repeating the name of the case. The name of the case is Sunil Chablani versus Commissioner of Income Tax International Taxation, and this case is reported in 116 ITR Tribunal at page number 187, and the matter has been decided by Jaipur ITAT B bench on 22nd July 2024. Thank you, friends.